All right, good morning, gentlemen. Welcome to oral argument session here at the Fifth District Court of Appeal. I'm Judge John Harris. I'll be presiding over the hearings today. Joining me on the panel, Judges Adrian Soud and Judge Jordan Pratt. We have one case we're going to handle today. I appreciate counsel working with us to get this rescheduled so quickly. The case on our docket today is 23-1062 Zimmerman versus Florida Gaming Control Commission. Our hearing today is being recorded as well as being live streamed on YouTube. And I would caution you at this time, if you do have any cell phones or other noise-making devices, please go ahead and silence those or turn them off at this point so that our hearing today is not interrupted. Each side gets 20 minutes for the argument. Appellant, you can reserve as much of that time as you would like for a rebuttal. The default will be set at 5 minutes. If you'd like anything other than that, please let me know, and we'll certainly make that accommodation. So this time, counsel, for the appellant, if you are ready, you may proceed.
Oh, thank you, Your Honor. And the 5 minutes, I think, would be sufficient.
Very good.
Thank you. May it please the court, David Romanek for the appellant Ramsey Zimmerman. The remedy that we're seeking today is to have this court set aside the order of the appellee Florida Gaming Control Commission, who I'll just call the commission through this argument, that denied Mr. Zimmerman's application to participate in the Florida pari-mutuel industry as a jockey, and that we seek the immediate issuance of that license as a result of this hearing. The main two arguments that were presented in Zimmerman's brief both emanate from the commission's violation of the provisions of section 12068 sub 7 sub e sub 3 of the Florida statutes, which provides that a reviewing court may set aside agency action that is inconsistent with officially stated agency policy or prior agency practice if deviation therefrom is not explained by the agency.
Are policy and practice synonymous with precedent?
Well, that appears to be the way that all the cases have been decided, Your Honor. I haven't really seen any cases that differentiate rulings and prior orders based on policy or practice. But certainly we have a practice here regarding jockeys and exercise riders that's been established through the three final orders that I've cited throughout my brief probably too many times, and that certainly that I presented to the commission both through a request for production when this case was pending at DOA.
Mr. Romanek?
Yes.
What is the minimum number of cases that, in your view, constitutes an officially stated agency policy or practice? Is it one case? Is it three? How many cases does it take to establish a policy or practice?
Well, Your Honor, in the Villa Capri case that I cited in the brief, it was one case. So again, I haven't seen any decisions when the number of cases that prior orders has been a factor, saying, if they're inconsistent ones, that might be something different. But the Villa Capri case is rather clear that if there's one order of the agency that's contrary to the position that they took, that then we have to go through the process of either having consistent decisions or some explanation why that one case was decided incorrectly and that warrants a different approach than what was done before. Here I have three. So, and I don't have any that are contrary to those three. And, you've seen in there that the commission complained that I picked 1% of the cases that they sent me. And I read all 300 of the cases they sent me, and there was not one case within that 300 that was contrary to the three cases involving the two jockeys and the exercise rider, which cases, by the way, I already knew, and they were specifically listed in my request for production for those three cases, because I knew about them. And there's a very small community of lawyers that represent people before first the division and the commission. And those cases were handled by colleagues of mine. So I knew about them. In fact, I relied upon the Gaffleone case when I handled the La Pala case. And those were very consistent.
The policy or the practice of the commission here is to grant these felony waivers, right? Under certain, so to grant a hearing and consider granting a waiver. So if they had decided in this case, you know what, we're just not even going to have the hearing, that's a change in policy or practice that would require some explanation. But the fact that they followed their policy and practice, and you just didn't get the outcome that you thought you would get based on some earlier cases, is that really a deviation from policy?
Well, I don't know if it's a policy or a practice. It's certainly a deviation from practice. So when they set guidelines, and again, they could have adopted a rule that handled all this. They prefer to do it on a case-by-case basis. So if they're handling it so that a grade 3 felony for Gaffalione he has to wait 1 year and he gets licensed. And for LaPala, it's a grade 3 and she had to wait 1 year before she got licensed. And then now we have a grade 1 felony through Juarez, which is the case I was relying on, which is armed robbery, and they grant him a license after 4 or 5 years. Then to me, there has to be some consistency. I view those cases as being consistent, but I don't view Zimmerman's case as being consistent with the holdings in those cases, because I think they've established, whether it's a policy or a practice, that for grade 3 felonies, it's a year. For grade 1 felonies, it's 4 years. But if you look through, I mean, there's no discussion in any of those cases about any of the factors that they relied on, saying 1 year was enough, or 3 years was enough, or 5 years was enough. And to me, if you look at the decision in McDonald, which I've cited, and as I'm sure the court knows, that these decisions, the two main decisions I'm relying on are Willis and McDonald. They were both decided in 1977. They were 2 of the 3 first interpretive cases of the new APA that was adopted in 1975. And in McDonald, the court said that the final orders must display the agency's rationale for its decision and must address countervailing arguments developed in the record or by a party's written challenge of agency rationale in informal proceedings, or by proposed findings submitted to the agency by a party. I did all that. I submitted my countervailing arguments, and they refused to address any of those, trying to differentiate why Zimmerman's case was different than any of those cases, and why he shouldn't have the same relief granted to him that those 3 people who were applying for the same exact licensure that he is.
Romanek, it seems like your argument collapses down to the issue of whether or not those cases are meaningfully distinguishable. Because if they are, and I understand you argue that they're not, you think that that there's no meaningful distinction. If there is a meaningful distinction, even under your view, there is not an officially stated agency policy or practice that governs this situation, correct? If the cases that you have cited are meaningfully distinct from your case, then there's not an agency policy or practice that requires, under these circumstances, the granting of a variance. And then by virtue of that fact, there would not be a duty of the agency to explain why those cases are different, because there is no on-point agency policy or practice. Is that correct? And if not, what's the break in the logic there?
Well, the break in the logic is that I presented countervailing arguments. So if what you're saying is correct, and they are distinguishable, then it was the duty of the hearing officer to distinguish them in the final order or in the recommended order. Not
okay,
to
so then your argument then is that even if the prior cases of the agency are distinguishable, they nonetheless constitute an on-point policy or practice, a departure from which must be explained. So is that your position then, that even if the cases are distinguishable, it is nonetheless an on-point agency policy or practice? Is that the argument that you're submitting?
Well, yes. I'm not sure I exactly agree with that, but I think it's close enough that yes, I would say that. And then I would also point to the recent decision in Citizens of Florida versus Graham, which involved the PSC when there was a settlement agreement among certain parties, but there was a disagreement about that by other parties to the case. And the court said that the PSC was required to address the arguments of the folks that did not join in the settlement agreement and explain why their position does not cause the agency to have a different position. So I'm saying that once these things are presented, the agency just can't ignore them like was done here. I mean,
Okay, so let's have a hypothetical then. Let's say that, we're presented with only 3 cases that the agency has ever decided under the statutory provision, and they are clearly on their face very different from your client's case. Would you still be arguing that there exists an agency policy or practice? Is there some point at which, the complete distinction of the cases that have been decided before, you'd look at that and say, well, no, there's not an agency policy or practice yet with regard to the circumstances presented by my client? Or would you instead say, well, they've decided 3 cases under the statute, and even though they dealt with circumstances totally different, right? The age of the conviction, the seriousness of the conviction, whatever we might say is we might get some agreement from you is meaningfully distinct. Would you nonetheless say that the fact that they have 3 cases decided under the statute at all, regardless of the circumstances of those cases, that constitutes an agency policy or practice which requires a written decision in every single one of the cases that is decided under the statute? It seems like that's a logical implication of your argument. I'm just trying to work out why that wouldn't be the case.
Well, of these 300 cases that I looked at, most of them had to do with poker dealers who had felony convictions for theft. I didn't cite any of those because I didn't see any relevance to those decisions to mine. I picked out of all these cases, the 3 cases that involved the same parimutuel occupation, which would have the same good moral character aspects to it. And, it's like anything else. I mean, if we're talking about a tax exemption, you look at the statute regarding the tax exemption and the cases decided under that have some relevance, some connection, some nexus to what we're talking about. So I guess my point here is that I picked out the cases involving the same parimutuel occupation, and they were consistently applied by the Division of Parimutuel Wagering. Everyone.
Well, perhaps, Mr. Romano, the theft cases with the dealers have more relevance than you're giving them credence, because they do have something to do with the job for which they were seeking an exemption.
Correct.
It seems like your client's crimes occurred on parimutuel property or involved enhancement or affected his performance as part of the parimutuel wagering business, similar to a dealer. The other cases that you rely on have nothing to do with parimutuel wagering, correct? Didn't occur on parimutuel property, didn't affect their performance as a jockey. Isn't that a clear distinction with your client?
Well, I guess the problem I have with what you just said, Judge, is nothing that he did had anything to do with his occupation as a jockey. He may have been on parimutuel property when he jumped into a running car and drove it from one parimutuel facility to another. But I'm having difficulty understanding how that would affect his ability to be a jockey. I mean, to me, it falls closer to what happened in Gaffleone and La Pala when there was I don't know, it's like some instantaneous stupidity that caused those things to happen. But what he did has nothing to do with his performance as a jockey. No one has ever complained about anything having to do with him being a jockey. It just, so it may have happened that he drove from a training center to the racetrack, but I'm not seeing the nexus between that and his ability to ride a horse and to ride it in good, ride it to the best of his ability. So there's no claim of race fixing or anything having to do with his performance as a jockey. That's why, that the case that I cited about the Florida bar and the lawyer who was admitted homosexual, they said, what's the connection between these things? There's none. I don't see any connection between the fact that he may have jumped into a running car at the training center and drove it to Gulfstream has anything to do with good faith as a good moral character as a jockey.
Nothing about the dangerous diet he was on and the use of cocaine to get down to a certain weight to make him eligible to ride.
Right. Well, I understand all of those things, but that was 5 years ago. I mean, that's not now. I mean, Mr. Juarez was involved in an armed robbery. I have a hard time justifying someone who's who goes to federal penitentiary for a year because of a grade 1 felony, and he gets licensed. But now this person, I'm just not seeing the connection there. I understand it may have been on parimutuel property, but it wasn't a parimutuel event. So, I mean, but again, what happened? So is this a forever ban because he jumped into the car at the training center and drove to the racetrack? I mean, that's the part of this, a final order that falls apart for me. Serious crime and too recent. Well, how do you look at those crimes, the seriousness of the crime? Compared to armed robbery, I don't think we get there. Class 3 felony versus class 1. 5 years. It was the same for the person with the class 1 felony. But is there an end to this? Is this it? He joyrided in a car from one place to another, so now he's banned forever from being a jockey? I'm just not seeing the connection when we look at the other 3 cases. They were all given a second chance. What is it about him that he doesn't get a second chance? And now, because of Florida banning him, he can't get licensed. He's licensed in 2 other states, but all the other states have turned him down because he's been turned down by Florida. So now he's basically out of the business a third of the year because he could only found 2 places where he can ride. And I'm having trouble again seeing the nexus between what you're saying, what his job as a jockey, and joyriding in a car. I don't see the connection.
You're 30 seconds into your rebuttal. Would you like to reserve the remainder of your time?
Yes, I would. Thank you.
Thank you, sir.
Good morning.
Mr. Woods.
Yes, sir. May it please the court. Steve Woods on behalf of the FLE, the commission. Your Honors, I would begin with what is actually the issue. I'd respectfully point out that at no point, as far as I heard, at no point was the actual issue below discussed. The issue for the hearing officer was whether this man proved that he had good moral character and that he had been rehabilitated. This zeroing in on recency and severity is the problem with the appellant's argument. That is our position, respectfully stated. Of course, the felony is the starting point. The felony and the recency. It is not the entirety of the issue. I'm not quite sure how to put this. You commit a felony, and of course, the felony is the obstacle to be overcome. So in this case, you have multiple felonies. So the felony is the hole into which a criminal digs himself. And the issue is whether he has taken himself, whether he's dug himself out. So he is really perseverating on the degree of the felony, the recency of the felony. Would also point out the recency of the felony, but that's not automatically relevant either. The time is relevant only insofar as a person has made good use of it. So the fact that it was 10 years ago isn't automatically relevant because the person may not have changed. And the fact that it was 1 year ago is not automatically prohibitive because someone could have changed a great deal in a year. So the issue below was whether this man proved that he had good moral character and that he had been rehabilitated. And I didn't hear that addressed once. It is nothing but this focus, this zeroing in on what is not the issue. The issue is not recency and severity alone. There's not one case that stands for that. It is nowhere to be found in the statute. There is no rule. There's no basis for it whatsoever. The issue, he cannot prevail on the issue, so he changes the issue. So that's what's going on here. My second point would be that I heard opposing counsel talk about nothing to the contrary in these other 278 cases. These cases, they're not part of the record and therefore they can't be considered. So he says, well, 3 cases. I didn't include a lot of cases because, listen, they're irrelevant. He can't say that. That is referring to a matter outside the record. That's an improper argument. And it's one the court can't consider. So the issue on appeal, of course, is whether there was anything that was inconsistent with a prior agency practice. So here you have these 3 cases, Gaffalione, La Pala, and Juarez, that we know there are 300. He has taken this small sample and he claims, he asserts, that this is a practice. That's step one, but he skips over actually establishing that there is a practice. If it were to be a practice, this would have to be something customary, something usual, something repeated, something normal, something that is systemic. It's not. He just repeats frequently, very frequently, this is a practice, and he never accomplishes step one to his argument. There simply is no practice from which the commission deviated. The cases on which he relied, suppose I'm wrong about what I just said, that, there actually is a practice, supposing that his 3 cases is roughly 1% sample, which, by the way, the actual numbers, this is 3 to 300 is what 12 seconds is to 20 minutes. So if I were to drink water for 12 seconds and you were to say, Mr. Woods, you have a practice of drinking water during oral arguments, and that's a practice you need to rethink. It's not a practice. It is a blip on the radar. It doesn't even scratch the surface. So the burden is on him. He would have to establish, some very obvious things. If you're saying it's a practice.
So, Mr. Woods, it sounds like you would concede that at some point there's some critical mass of decisions, of cases, which would establish an officially stated agency policy or practice. Is that sort of what you're conceding here? So then I guess I would ask, if that is what you're conceding, the second question would be, at what point, or what proportion of cases would constitute a policy or practice?
Yes, sir. Your Honor, so in this case, we have the 300, we have the 3. So to answer your question, we can see that at some point, repeated, systemic, normal, customary action becomes a practice. And your next question, at what point? Well, far, far, far above 3. I mean, to have a practice, 2 things come to mind just from the standard definition of practice. You would have to have a substantial percentage of the cases establishing what you claim is the practice. And additionally, you'd have to have nothing countervailing, nothing countermanding, nothing to the contrary. This case doesn't even have that. My next point would be, even if you disagree with everything I just said about the practice, I mean, that ends his case. There is no practice. He tries to create one by more or less ad nauseum repetition, that you cannot will it into existence by repeatedly stating it. It just doesn't work. But if he were right, the Gaffalione, LaPala, Orez, they're all readily distinguishable. I mean, Gaffalione, this is a case where you're dealing with a young man. This is someone who was very recently out of high school. This is a one-time occurrence. This is something that occurred at a party. Mr. Gaffalione saw a woman being mistreated, and he inflicted minor injuries upon this person who was mistreating a woman, and the parents of the injured youth insisted that Gaffalione be charged. And
so I guess, Mr. Woods, then I'd ask you the same question that I asked your friend on the other side, which is, doesn't it sort of beg the question or collapse the inquiry all into the issue of whether or not cases are distinguishable? Because it seems like what you're saying is, if there are cases out there, but they're distinguishable, then there's not a policy or practice, and therefore the agency has no duty to distinguish them. Whereas if the cases are not distinguishable, the agency can't distinguish them, right? So it seems like, the arguments that are being presented, from both you and your friend on the other side, really hinge on the question whether or not the cases are distinguishable, putting aside, of course, your point about, what proportion of cases would be necessary to establish a policy or practice. Once we hit that proportion, whatever it is, it seems like the issue is simply whether the cases are distinguished or not. Because, again, if they're distinguishable, there's not a policy or practice, and you have no duty to distinguish under your argument. But if they're not distinguishable, then you can't distinguish. So I'm trying to see, under your theory, what work is the statutory requirement of articulating the reason for departing from an agency policy or practice? When does that ever actually apply? It seems like there's no space for that statute to do any work.
Yes, sir. I suppose I can answer part of that question by first stating that you don't, in this case, you never get to the question of whether the cases are distinguishable, because he never made the preliminary, the threshold. He never did what he had to do at the outset, which was establish a repeated, customary, usual action. You never get to ask the question, is Goffolione distinguishable? You don't need to. Is LaPaula distinguishable? We can do that, and I'll go through all of that. I'll go through each of those cases one by one. But he does not have a practice from which he can begin. The practice is simply non-existent, so he cannot show that there is anything inconsistent therewith. If it pleases the court, I'll go through the cases and distinguish them. Yes, sir. So Goffolione, again, this is a very young man. He gets into a fight. The parents insist that this youth be charged. He has a different type of evidence from Mr. Zimmerman. He has friends. He has members of the racehorse community. In the order, it said that he was young and he had learned his lesson. The appellant in this case was something like 35 when these multiple felonies occurred. Mr. Goffolione had a one-time occurrence in his youth. Similarly, Juarez, another young man. This is an armed robbery, as Mr. Romanek correctly points out, but he too was young. This is after his high school graduation. And this is something that the hearing officer found credible testimony that a passenger in the vehicle did this. And this passenger is someone with whom Mr. Juarez cut ties. So he takes steps to beat his drug addiction. He goes to Reformers Anonymous. He works long hours. This is another case in which you have a one poor decision by a very young man. Now, again, appellant was in his 30s, and he did this, as the court pointed out, on parimutuel property. LaPaula, too, is easily distinguishable. The evidence alone, this is someone who had 11 letters, 5 persons with personal knowledge of LaPaula, and then there were 6 others, a letter from a psychologist, a letter from the treatment facility, a letter from the probation officer. So this is someone who was going to continue with psychiatric treatment. And you compare that with Mr. Zimmerman, who had testimony from Mr. Fox, who did not know him well, and not surprisingly, the hearing officer said, well, Fox is credible, but has limited dealings with Mr. Zimmerman, and therefore his testimony is of limited value. These cases are readily distinguishable. We do win on that, but you don't even have to get there. Step 1 is there a practice? The answer is no. Step 2 is, if there were a practice, can we distinguish the cases that are allegedly the cases that make up the practice, that form the practice? And the answer to both of those is no. So that's our position on that. And
going back to just like the theoretical framework, I'm just trying to make sure I've got a handle on it. So the statute that we're talking about here, it says that the agency's exercise of discretion was inconsistent with officially stated agency policy or practice, or prior agency practice, if the deviation therefrom is not explained by the agency. So, I mean, if an agency policy or practice can be established by prior cases decided by the agency.
Yes, sir.
And if those prior cases are fairly distinguishable, then wouldn't it be the case that there's not a deviation from agency policy or practice that would need to be explained? Is that what I'm hearing from you? So we're focusing on the deviation portion of that subsection of the statute.
Yes, sir.
Okay.
Yes, sir. Yes, sir. So if in a case in which there is a practice and then the instant case is distinguishable from the cases that form the practice, then yes, then this court would have to affirm the final order because there would be no deviation therefrom. If that answered the court's question, I'll make one point about the evidence below. The first thing I said, is that Mr. Romanek zeroes in on this recency and severity, as if that were ever the question. The question below is whether the person has established good moral character. So again, the felony is only the obstacle to be overcome. It doesn't tell you anything about what the person has done afterward, nor does the time. You have to show that you actually use that time well. When he was at his hearing, he has this guy, Fox, come in and say, well, it's really rare to have interactions with jockeys, something like that. And he says, yes, jockeys are important to me, but I don't know them personally. Mr. Fox had limited interactions with Zimmerman, and accordingly, he had testimony that was not of great value. And then you have Mr. Brennan, who writes this letter, which says essentially that Mr. Zimmerman is a talented and model employee. And then, of course, you have the testimony of the appellant. So the burden, of course, is on the appellant, and he doesn't produce much evidence. He doesn't produce the quantity or quality of evidence that we saw in LaPala and Juarez, Leone. For example, LaPala, this person produced 11 letters from a very diverse, eclectic group of people. In this case, we just have Dr. Fox, who more or less knows this man in passing. And the testimony of appellant, which isn't even that favorable for appellant. I mean, I think he admits to taking cocaine. He stole a car while selling drugs. He goes into his issues with anorexia, bulimia, cocaine, energy pills. And he was doing that kind of stuff to lose weight, which is exactly the situation he would be in if he got his license. And that was the problem to begin with. He was trying to lose weight, and he was not in a good state of mind and committed these crimes. And one of the concerns, of course, was that he would be going back to the very state of mind in which he committed the felonies. So you can zero in on recency and severity if you like, but it gets you nowhere. When you talk about the degree of the felony, well, that is what the legislature said. Okay, that is the, some crimes are more serious than others. But again, the felony is merely what is to be overcome. It does not tell you what the person has produced to overcome the felony. So the issue is not some mechanical comparison of, severity divided by recency, and it gives you this number. There's nothing like that. It is not a two-factor test to the exclusion of all others. It is the entirety of the circumstances that an applicant produces to show that he or she has, you have the felony, and the felony is the depth from which one must ascend. So you prove a good moral character and rehabilitation by whatever evidence you like. Of course, it is not limited just to the recency and severity of the felonies. Your Honors, I'm reviewing my notes to see if there are any other points I can address. Maybe one last point about it. Probably made this point too often about there being only 3 cases out of 300. And Mr. Romanek says, well, there were none that were contrary to it. This relates to the practice of, what is a practice? Well, that is a problem for the appellant. He has to establish, he has the burden. So he can examine whatever cases he wants. He can choose as many as he believes to be favorable. But what he has done doesn't even scratch the surface. So again, it's like my comparison about if you take 1% of cases, it is next to nothing. It is, like I said, 3 to 300 is 12 seconds to 20 minutes. It is nowhere near a practice. It's certainly not substantial, and we don't know that there is nothing contrary there too. A practice requires a serious survey of the entirety of the action in question. So if there are no questions, I would just briefly summarize my position. First of all of this is his burden. We win this case because he has not established any practice. That settles the entire case. Even if I were wrong about that, we win because Gonfalone, LaPala, and Juarez are clearly easily distinguishable. I won't repeat the reasons, but they have nothing to do with this case. They deal with young people, they deal with a different type of evidence. They are obviously distinguishable. And that is the entirety of the commission's case. If there are no further questions.
All right, thank you, counsel.
Thank you.
All right.
Dominic, about 4.5 minutes.
Yeah, thank you. Well, first of all, the 300 cases were not only given to me, they were given to the other side too. I mean, they were their cases. And I know Mr. Marshman, the general counsel, complained that I plucked these 3 cases. Well, he couldn't pluck one out of the other 300 involving a jockey that were contrary to those 3. So I'm kind of missing this whole thing and not establishing precedent because there are only 3 cases involving jockeys out of that whole group. And he didn't cite any cases. No one on the other side has cited one case contrary to those 3 cases. Now, as far as this argument, though, that the seriousness and the timeliness were not the only issues, longstanding principles of administrative law require this court to review the ALJ's decision based on the reasoning and factual findings offered by the ALJ not post hoc rationalizations that attempt to intuit what the adjudicator may have been thinking. The only thing in that recommended order regarding any issue of good moral character was paragraph 25 that said, while petitioner's testimony was credible, petitioner's felony convictions are for serious crimes, not as serious as Juarez, and petitioner's convictions occurred only a few years ago. Well, same thing with all of those. It's difficult for an applicant to prove rehabilitation from such serious convictions in such a short period of time. That was the only thing that the hearing officer ruled. Yet, let's compare it to the other three. Same class of felony, 1 year. Same class of felony, 1 year. Higher class of felony, 5 years. So the one finding that was made is completely contrary to everything that those three cases say. So, again, I don't know how.
The hearing officer didn't say it would be impossible to prove rehabilitation under these circumstances. She said it would be difficult. Doesn't that kind of mean that the burden wasn't met? It can be done, but you didn't put on enough evidence here?
Well, but again, as to but it was only two issues: seriousness of the crime and recency. Those are the only two things she stated that I didn't prove. Okay. But then I look at the other cases and they're less serious, or, especially Juarez, more serious in the same period of time. So I don't know what this means. I mean, there's no time frame in there. What is a serious crime? What do I have to show that it's not a serious crime? Or how long does it have to go before a crime happens that you get a second chance? All I can do is look at the other three, 1 year, and 4 to 5 years, and say, hey, I fit within that. I'm the same as they are. What's different? Why should he be treated differently? I think that's that's the point that's being missed here. I proved the precedent. The only three cases they've ever decided on jockeys, they had. And I don't know what more I had to do, especially under Villa Capri that says they only needed one case that was contrary, and that was sufficient for the agency to have to explain why it was different. Oh, I still have 59 seconds. Okay. And I will say one thing though, and the whole purpose of this of Willis, when it said that parties to these administrative cases have the right to locate precedent and to have it applied. This is what the 4th District said in Gessler. The purposes of these requirements is to protect citizens against arbitrariness, to give citizens the means of finding out whether they are receiving treatment equal to similarly situated persons, and to give the courts the opportunity to determine whether the agency is acting arbitrarily and even-handedly. And when the Supreme Court ruled in the Citizens case, they said that these same issues are the same requirements have been inserted into McDonald to make sure that there's even-handedness of treatment. That's all I'm asking for here, is to be treated the same as the other three people that came before this agency in the same condition as Zimmerman and want to be receive favorable treatment when he was denied under circumstances identical to Juarez.
All right. Thank you both very much for your argument. We're going to take the matter under consideration. The court will stand adjourned. Have a good day.
Yes, sir.